All right, be seated, everyone. We hear now the summation from the state. Go ahead, Mr. Sheldon.
Thank you, Your Honor. May it please the court, counsel, members of the jury, good morning. If you remember back to my opening statement 2 weeks ago, I told you that I was intentionally leaving things out. And that I was intentionally leaving things out because evidence doesn't come from me. It doesn't come from Mr. Belinkis, Mr. Deininger, Mr. Bennett. Evidence comes from witnesses. It comes from people who walk through that door, put their hand on the Bible, take the oath, and agree to testify. So no matter what Mr. Belinkis may have said in his closing, what I may say over the course of the next hour, that's not evidence. The evidence comes from the witnesses. And I start there because your verdict will be based on evidence. It's not going to be based on passion or sympathy or emotion. It will be based on evidence that you heard, evidence that you saw. Mr. Belinkis just spent an hour telling you what he thinks I think, what he thinks I'm going to argue. I hope that I won't leave any questions for you when I'm done. The verdict sheet that you're going to be given has one person's name on it, and that's the defendant, Michael Barisone. He's the one person on trial. He's the one person that you're going to go back in that room and deliberate, not about whether you like or dislike Lauren Kanarek, not whether you like or dislike Rob Goodwin, not whether you like or dislike me or Mr. Belinkis, or frankly, whether you like or dislike even the defendant. The verdict sheet is going to ask you whether the defendant is guilty, or not guilty by reason of insanity. Over the course of the next hour, I'm not going to tell you what to think. I'm not going to tell you what to feel. I'm going to point out things that I think the evidence shows, that I think the evidence will help you to decide this case. I don't have any remarkable catchphrases for you. I'm not going to cry. I'm just going to ask you to follow the facts and apply the law. Now, when you all got your jury summons several months ago, you were told what to do, when to log onto your computer, when to have your camera on, when to turn your camera off, when to be in the courthouse, what time to be here, where to go, when you can take a break, when you can talk to people, what you can talk to them about, what you can't. But the one thing that no jury is ever told is how to deliberate. When you go back through that door after Judge Taylor gives you the law, how do you apply the facts and the evidence that you heard to the law the judge is going to give you? So I hope that over the course of this closing argument, I'm going to give you something of a framework. You can use it, you can ignore it, but hopefully it will give you a logical starting point for how to examine those facts and how to apply them to the law. Mr. Belinkis ended his closing by pointing out those burdens of proof. And if you remember back to my opening statement, I told you the burden of proving the defendant guilty rests with Mr. Bennett, it rests with me, it never shifts. That's our burden to prove that the defendant is guilty of attempted murder and of possession of a weapon for an unlawful purpose. So that's where I'm going to suggest that you start your deliberations. But you're also going to hear the judge tell you that the defendant is claiming insanity in this case, and that the burden of proving insanity is on the defendant to prove. That's his burden. So I'll suggest that you address that second. Now, with respect to attempted murder, the judge is going to tell you that a person's use of a deadly weapon allows you to infer that their purpose was to cause death. The reason I start there is because that is such an important part of this case. Why did the defendant use the weapon that he used? It may seem obvious, it may seem simple, it may seem basic, but I'm starting there because he didn't use something that was in his pockets. He didn't use his belt. He didn't use his fists. You heard about the search of his truck. You heard about some of the things that were in the truck. The shovel, the tire iron. Things that when he drove to the house were there in the truck with him. You heard about the patio area. There was a rake there. There's flower pots. There's chairs. There are a number of other things that he could have picked up in that moment. And yet when he got into his truck, when he drove to confront Rob and Lauren, he went there with a deadly weapon. He picked that deadly weapon before he even got in the truck, before he even drove to the house, before he even got out of the car. He had picked that specific deadly weapon. This is the gun. This is the gun that he picked out of his safe to use. And I point that out because you heard testimony, you heard evidence that he had his own guns. He had a .380 caliber, semi-automatic, bless you, handgun in his safe. But what did you hear about that gun? There's no firing pin, there's no extractor, there was no ammunition for that gun. That gun was not an option. You heard about the .45 revolver. But again, you heard that that gun was in the safe, but there was no ammunition for that gun either. And lastly, you heard about his .22 single-action antique revolver. The importance of that being a single action, if you remember the testimony, and if you're not familiar with guns, is that in order for him to fire a shot, you would have to use your thumb to pull that hammer back, to prime it, to get it ready. And then pulling the trigger would shoot a bullet. But to shoot a second bullet, you would have to pull the hammer back again and pull the trigger again. So for each successive shot, he would have had to pull the hammer back and then shoot. You also heard about the way revolvers are loaded, that you don't just put all the bullets in at once, that you have to actually turn the cylinder and put the bullet in, and turn the cylinder again and put the bullet in. It takes longer to load. And that gun, for example, only held 6 bullets. Compare that to the gun he did use. Ruth Cox, 9mm, small, had 2 magazines, one of which was loaded with bullets, and that he put into his pocket, making sure that he was taking more ammunition for that deadly weapon with him to the scene. Do you recall when the safe was searched later that day? This is what it looked like. The case where the handgun was, the case that Ruth Cox gave it to him in, with that orange safety magazine in it. The orange safety magazine is out, the 2 magazines are gone, and there's a box of 9mm ammunition right below the gun, open and with bullets missing. Why is this important? Because the judge is going to tell you that just based on the fact that the defendant used a deadly weapon, you can infer that his purpose was to take a life. And he didn't pick up this deadly weapon when he first saw Lauren. He didn't pick it up when he first saw Rob. He didn't pick it up when he first got out of the truck or when he first drove there. He picked it up in the office out of his own safe. He knew when he opened the safe and took that gun exactly what he was going to do. His possession of that gun wasn't accidental, it wasn't incidental, it was purposeful. Now that inference, again, is important because the judge is going to tell you a number of things about the law with respect to attempted murder. But he's going to tell you that essentially Mr. Bennett and I have to prove 2 things to you. First, we have to prove that the defendant's purpose was to cause the deaths of Lauren Kanarek and Rob Goodwin. And second, that he did something that's what's called a substantial step. Again, I'm going to discuss why the evidence shows that the defendant is guilty of this crime. Do you recall where the shooting happened? I'm sure you do. You heard a lot of testimony about it. It didn't happen in the defendant's office. It didn't happen in the barn. It didn't happen at one of these times when Lauren Kanarek was supposedly creeping around and sneaking behind bushes and popping out of the dark. It didn't happen when the defendant just happened to come in contact with her. In fact, you heard testimony that the defendant and Lauren Kanarek had not even seen each other on August 7th. Everything that was going on between them in this week leading up, and on the day that he's charged with trying to kill her, they hadn't even seen each other that day until he went to find her. That's important because Ruth Cox gave the defendant that gun in the stables. And she said that she saw him take that gun back into the clubhouse in the direction of the office, the same place that we just saw where the gun case was found, where the orange safety magazine was found. The gun was in the office, it was in the safe, it was at the barn. The defendant was last seen in the office at the barn. And yet the shooting happened all the way a quarter of a mile up and down by the farmhouse, a place where the defendant had gotten into his truck and driven to. Before I talk more about the elements of this crime, I do want to discuss credibility. You heard a lot about the credibility of the witnesses. And basically, Mr. Belinkis said, you can't convict a defendant because the only evidence that he's guilty comes from two liars. Two, I think he said, despicable people. They can't be believed. Well, the judge is going to tell you that you're the sole judges of the facts. You decide credibility. Not Mr. Belinkis, not me, not the judge. It's you, the deliberating jurors. And that you do that just the same way you do every single day of your lives. You talk to your spouse, you talk to your kids, you talk to your parents, coworkers, friends. You're evaluating, is what this person telling me reasonable? Is it likely? Is it probable? Lauren Kanarek had 2 bullet holes in her chest. You saw the clothing. There were bullet holes in the clothing. You heard about the testimony about the bullet holes, the bullet hole in the side of the house. And Mr. Belinkis said Lauren Kanarek was shot twice in the chest, and that, like in a cartoon, one of those bullets was able to go out her back and somehow curve up and go out through the top of the house. Does that sound reasonable or probable or likely to you? You heard the testimony, and again, you'll have these exhibits for your deliberations, about where that reconstruction showed that the gun had been shot. That it came in through this door, grazed across this mat, and came at an upward angle through the back window. And if you remember, with the diagram, that basically shows that the gun was shot somewhere in the area of where that bush was. Physical evidence, uncontradicted by anything, that corroborates what Rob and Lauren testified to. You heard about the state of the gun, that when Corporal Heimer gets on scene and he pulls in and he sees 2 men struggling on the ground and he sees a woman bleeding and he rolls the defendant over, and underneath the defendant, not on the ground like Mr. Belinkis would have you believe, underneath 6'4" Michael Barisone's body is the gun. That Rob Goodwin is literally struggling for his life. I'm not exaggerating. That's not hyperbole. I'm not just saying that to make you feel emotional. You heard the 911 call. The 911 call where Rob Goodwin is saying, are you sending anyone? Are you sending help? Hold on. He's moving. He's moving. If you move again, I'll break your arm. His arm isn't broken at that point. Rob Goodwin is saying that while the 911 call is still connected. And then when Corporal Heimer comes in and sees this scene and rolls the defendant over and finds the gun just like that, just like Rob Goodwin testified, when I looked back, I saw the slide was back because the gun was out of bullets. And I was just holding him on the ground, waiting for someone to get there. And Corporal Heimer, who's working a road, third-party road detail or whatever he called it, gets a call that there's an active shooter at this property. And he pulls in by himself, and he says he can't see what's going on in the backyard. There's a huge dually, a big silver pickup truck in the way. And he comes around, and he's got his gun out. He doesn't know what exactly he's going to encounter. And he sees a woman bleeding. And he sees another man saying, this is the shooter, holding him down. And he pulls him off, and he finds a gun underneath his body, and he takes the magazine out and he throws it. And what does Corporal Heimer say? Not Rob Goodwin saying, if you move, I'll fucking kill you. That's Corporal Heimer saying that, and it's all recorded. You heard it all on the 911 call, which corroborates everything that Rob and Lauren said happened. This attack didn't somehow happen before the 911 call, and then I guess they had time to, walk around and plant evidence in certain places, plant a cell phone in a certain place. Do you remember where the defendant's cell phone was? It's on this table, right here. The exact place where Rob Goodwin and Lauren Kanarek say that they see the defendant. Both of them testified they didn't see him get out of the car. They didn't see when he walked over behind that bush to hide himself behind the bush. They couldn't see if he had anything in his hands. And yet Mr. Belinkis would have you believe that after this shooting happens, that after they beat up Michael Barisone, they're going around planting cell phones in different places. What else did you hear about the scene? Corroborating what Lauren and Rob said. Well, emergency personnel are showing up. Corporal Heimer is there, Officer Wurtenberg's there, Officer Hensley's there, and now it is a free-for-all. There are officers there, there are multiple ambulances there, they're trying to separate people. Isn't it more probable and likely and satisfying to you that somebody moved those cell phones and put them at the base of the umbrella, not Rob Goodwin or Lauren Kanarek? You heard about the weather that day. You heard about the fact that within about an hour of this shooting happening, that the skies opened up, and you saw the pictures. You don't have to take anybody's word for that. You saw pictures of evidence that's literally in inches of standing water because the rain came down so fast and so hard. And Mr. Belinkis says, well, they didn't look for fingerprints on the soaking wet shell casings. They didn't look for fingerprints on this or that. He said they didn't look for gunshot residue. You heard that they looked at the clothing and that it was all soaking wet. You heard that that's a tool that they use. It doesn't show definitively who the shooter is or who the shooter is not. It's a tool that they could possibly use. So back to Lauren Kanarek and Rob Goodwin. Back to credibility. Would it be more satisfying to you if Lauren Kanarek came through that door, came in here, Mr. Belinkis held this up, put her hand on this and said, I'll tell the truth. And then Rob Goodwin said the same. And then they testified to exactly the same words, exactly the same things. Would you feel like that was rehearsed? Like that was fake? Like that was made up? Or do you find it more satisfying that in this unexpected moment, and I'll get to the defendant's state of mind and his emotional state in a moment, but they both describe that he gets there and he's calm. They can't see him, he's hiding behind the bush, and he says words to the effect of, how can we end this without a war? And Lauren Kanarek comes down off the step to talk to him. Then he lifts up a gun, and he points the gun. And when she's no closer than I am to Mr. Belinkis, he starts shooting her in the chest. And Mr. Belinkis says, well, you can't believe anything she says, because at that point, when her body cavities, her torso is literally filling up with blood, her lungs are punctured, you heard that testimony, and her body is filling with her blood as it's pumping, not into her veins, but into her body, that she feels like it's an eternity. You heard her on a 911 call. Was that fake? Was she acting? I've been shot in the heart. Help me. Michael Barisone shot me in the heart. Was that fake? And then Mr. Belinkis did an act where he walked all around the courtroom and showed everything that he thought that Ms. Kanarek was testifying about what she did. I don't remember her reenacting that for us. I don't remember her doing all that. It's your recollection that it controls. That's Mr. Belinkis' version of what she testified to. If you think about what she actually testified to, she said, I didn't know where I went. I disappeared. I walked around and I'm patting my chest. She didn't believe that she had actually been shot in that moment. And Rob Goodwin, again in that moment, is struggling for his life. He sees the gun, that picture that we saw where the slide is locked back because it's out of bullets, and he's fighting for his life. And he's just trying to hold the defendant down until police get there. Doesn't all of that corroborate what Lauren and Rob said? The last thing I'll mention is the dog. You heard a ton about the dog in this case. You heard the dog. You heard this vicious, you heard Cujo barking on the 911 call. Barking, yapping. I can tell you when I'm wrestling with my kids, and if the dog is there, the dog jumps in, and the dog is not Cujo. I don't have a vicious junkyard dog. But my dog has a tendency to jump in there and kind of start nipping and getting into the mix with us. Isn't it more logical and probable and reasonable to think that after the defendant had just shot Lauren Kanarek, taken a shot at Rob Goodwin, and Rob Goodwin is literally struggling for his life, that that's when these dog bites occur? Now, the issue of credibility doesn't just apply to Lauren Kanarek and Rob Goodwin. It applies to every witness. So every witness who came in here is subject to you considering, are they worthy of your belief or not? Did they testify with an intent to deceive you? Were they evasive in the way they answered questions? Now, you heard testimony or an argument from Mr. Belinkis about Stephen Tarshis. And I'm sure you all remember when Mr. Tarshis testified. My impressions of Mr. Tarshis are that he was very prepared. He was very professional. He was very knowledgeable about what was going on. And I would submit to you that it was not a mistake that he didn't say anything, not a word on direct examination about that eviction complaint being fake. Mr. Belinkis brought out everything he brought out. He's such a great cross-examiner that he got the truth out for you. Do you remember when Mr. Tarshis testified? Mr. Tarshis testified that on August 5th, he sent a letter to Lauren Kanarek. He sent a letter that basically said, things aren't working out here, you need to leave. He said that letter wasn't signed. And he was asked the question on direct examination, did you send a signed copy to her too? And he said yes. Then he was shown a verified complaint. That's what he called it, verified complaint. He said, yes, I sent this through a courier service or something of that nature on August 6th to Lauren Kanarek. I sent her that eviction notice. That was all the testimony you heard about it on direct examination. And it wasn't until cross-examination, when he was shown a copy of that verified eviction complaint, that he said, well, this was never signed. That wasn't real. Michael Barisone wanted me to send that to scare her into leaving. The man whose defense in this case is that he was crippled by a delusion of fear, such that he had to go and kill or be killed. This same man is telling his lawyer to send Lauren Kanarek a fake eviction notice to scare her to leave. And then that witness left that detail out when he testified on direct examination. You have to question everything that every witness said, not just Lauren Kanarek, not just Robert Goodwin. So the defendant is telling his lawyer, send her a fake eviction. Do you remember when Mary Haskins Gray testified? And I asked her about some of the text messages that she was exchanging back and forth with Michael Barisone in this week leading up. And there was a text message that she had sent to him. It's in evidence. You'll have it for deliberations. Can we please just tell them to leave? Still, no one has told them to leave. And his response was Monday morning. I'll take care of it Monday morning. Meanwhile, he's talking to his attorney behind the scenes. Send her a fake eviction notice. Let's try and scare her to leave the property. And the question was asked, who would do this? Mr. Belinkis said that about Lauren Kanarek over and over and over. Who would do this? Who would do this? He screamed. The defendant is doing the exact same thing to her. What was going on at 411 West Mill Road in August of 2019 is not hard to understand. It's based on emotion. And you all know that because you have life experience. I'm sure you've had disputes with people, disagreements, whether it's at your job, whether it's with a family member, it's at school. You understand how some of these politics work? People don't necessarily want to address something face to face, and so they do it through back channels. So what was going on at this farm, you may not know all of the ins and outs. I think Mr. Tarshish said that the equestrian community was kind of incestuous. So you may not know all the ins and outs of the dressage community. But what was going on there is no different than things that we've all experienced at various points in our life. So take, for example, that there are various levels of rider. You have people like Mary DeFranco, who has the means, she has the wherewithal, the ability to own horses, to own a number of horses, to keep them at farms. She can take off from work for weeks at a time, travel to the farm, go train there, and she basically said she does it as a hobby. She enjoys doing that. And then you have someone like Stephen Tarshish, who testified he's more of an enthusiast. He likes to ride, he said, 5 days a week, 15 hours a week. He said he competes in competitions, but he's also realistic about his capabilities, about his limitations. He knows he's not going to ride in the Olympics, but he just loves it. Then you have people like Lauren Kanarek and Mary Haskins-Gray. These are riders who are training because they do have aspirations to get to those higher levels. And I think you heard Lauren testify, one of the reasons that she didn't really want to or like working with Mary Haskins is because she felt like they were sort of too much of peers. They were too competitive. She wanted a trainer, somebody who had been there, who had been to those highest levels, someone she wouldn't be in direct competition with. And that was one of the reasons she didn't want to work with Mary Haskins. But you have these people who, they do have those aspirations to get to the higher levels. And then at the very top of the sport, you have the people who have been there. Boyd Martin, Philip Dutton, Alison Brock, the Olympians, the Grand Prix, creme de la creme, the internationally known riders. And they all came in and they testified for Michael Barison. They said, we accomplished those things because of this man, because he helped us get to that level. These are his friends. Lauren Kanarek testified that one of the issues that was going on in that week leading up to the shooting is that her career, her riding career, was being threatened. And the very people that the defendant calls to testify in his defense are the elite. They're the people who are at the top, the people with influence, the people with power. And they're here testifying in his attempted murder case about what a great guy he is. He's legendary, he's brilliant, remarkable. Mr. Boyd said, I love the guy. The defendant is sending Mary Haskins text messages that says, I will get her a lifetime ban. He is out to destroy her ability to compete in this sport. And then the people that he calls to testify sit on the USEF Board of Directors. The same agency that the day before the shooting, Mary Haskins is going to the UPS store, making copies of 750-some pages of bad information about Lauren Kanarek, putting in the overnight mail and sending to the USEF. Who would do this? Who would do this? Apparently it wasn't just Lauren Kanarek. The defendant was doing the same things to her. Now, I said before, this wasn't a random shooting. This wasn't just the defendant happening to come across Rob and Lauren in a dark part of the property. And I know that Mr. Belinkis pointed out, well, you had people like Mike McGrain testify, and Mike McGrain said, oh yeah, there was one time that Lauren Kanarek was dressed like a ninja, and she came jumping out of the dark at me, and she had no shoes on, and she had all black on, and it was terrifying. And then I pointed out, the day that this shooting happened, he never said a word of that. He never said a word. Does that make any sense to you? Is that at all satisfying? There's no question these people were not getting along. I am not asking you to go back and deliberate and think that it wasn't on both sides. You heard about all the Facebook posts. You heard about calls to the town. You heard about calls to 911. You heard about the police coming, the town coming. Reports to the USEF, reports to Safe Sport. This is two groups of people that are not getting along and do not like each other. But that's not a delusion. When the defendant went to confront Lauren and Rob that day, he was acting impulsively. He was acting emotionally. But he was acting purposely. And that's the standard for attempted murder. Whether or not the defendant acted with purpose. Did he surrender his restraint to impulse and to emotion? And did he act in that moment without stopping to think? Yes. There's no question about that. That is what the evidence shows. But the evidence doesn't in any way show that Lauren Kanarek and Rob Goodwin lied about when the defendant got out of the car and was holding a gun and pointed it at them and shot at them. And I would submit that the evidence shows the defendant is guilty of those crimes. Now, the second part of where I'm going to suggest that you go during your deliberations is with respect to the defense of insanity. And if you remember, Mr. Belinkis said it, this is the defendant's burden. The judge will tell you this. Mr. Bennett and I, the state bears no burden of proving or disproving that he was insane at the time of the shootings. That's his defense. Even though that was the case, Dr. Schlesinger testified, and I'll talk about him in a moment. But with respect to the defense of insanity, I think it's important to focus in, number one, on the existence of a mental defect. Because the judge is going to tell you that the defendant has to be laboring under a defect of reason from disease of the mind. Now, all the doctors agree that the defendant has depression, he has anxiety, he perhaps has personality disorder, but also agreed that none of those mental disorders would affect a person's ability to appreciate the nature and quality of their acts, or to appreciate that what they were doing was wrong. So when you're deliberating, the testimony about the defect of reason relates to that diagnosis of delusional disorder only. Which means that if you don't believe that the defendant can convince you that he has delusional disorder, then you should reject the defense of insanity. And to prove this defense to you, he called two doctors. And Mr. Belinkis called them, I forget what I wrote down, your recollection controls, said that they were both highly qualified, highly decorated doctors. You also heard that they relied on false information. They relied on inaccurate information, incomplete information. You look at experts the same way that you do with lay witnesses, police officers. You evaluate whether you think they testified with an intent to deceive you. And I start there because the defense called Dr. Hassan. Did you think that Dr. Hassan was forthcoming with his answers? Did he seem to be somebody who wanted to say what he wanted to say, regardless of what the question was asking for? I'll suggest that some of his manner of testimony was directly related to the fact that he's not as credentialed as the other doctors. You heard about Dr. Simran, Dr. Schlesinger. They both testified for both the defense and the state. They've both held positions with various organizations. They've published. They're board certified. Dr. Hassan has done none of those things. Do you recall Dr. Hassan's testimony about the DSM? The DSM, the authoritative test for diagnosing mental disorders. That's not me. That's Dr. Simmering and Dr. Schlesinger both testified. This is how you make a diagnosis. It's in its 5th edition. And I asked Dr. Hassan about feigned amnesia. He said, I didn't diagnose feigned amnesia. I diagnosed dissociative amnesia. Feigned amnesia is not a term that appears in the DSM. That's incredible. That's incredible because then you watched as we read together, not from some footnote in the back of the book, not buried on some page related to something unrelated to dissociative amnesia, the page that talks about dissociative amnesia, the same diagnosis.
Judge, I hate to object, that's not in evidence, and he showed it to the jury.
He's referring to it. It was referred to during the testimony of a number of expert witnesses, so it's fair game. It's not obviously going in as a piece of evidence, but it's fair game to comment on by the state. Go ahead, Mr. Shaw.
Thank you, Your Honor. The same diagnosis that Dr. Hassan told you, he gave to the defendant. And then we turned 2 pages, part of that same section, part of that same diagnosis, where it says feigned amnesia is more common in individuals with legal problems. The words feigned amnesia are not only in the book, they talk about the same diagnosis he gave to the defendant. Feigned amnesia, faking amnesia. It got worse. Do you remember what he said then? He said they must have made a mistake. The American Psychiatric Association, in publishing the DSM-5, the 5th edition of this book, they made a mistake. Dr. Hassan doesn't make mistakes. The American Psychiatric Association makes mistakes. Then I asked him about all the things he left out of his report. All the things that he testified to that didn't show up in his report. For example, what about when the defendant first obtained that gun from Ruth Cox? It wasn't that he just obtained it that day, the day of the shooting. He had gotten it from her several days before. He asked her for it. She gave it to him and she never saw it again. It was unloaded. Surely that could have some bearing on the doctor's diagnosis. And he said, well, I did discuss that with him. It's not in his report. And then he said, I didn't think that was important. He said, I ruled out faking amnesia. I gave him a diagnosis of dissociative amnesia. I gave him a diagnosis of delusional disorder. But when he first obtained the gun that he used to shoot 2 people, that has no bearing whatsoever on my report or my opinion. The last thing I'll mention about Dr. Hassan is about the tests. And again, it's your recollection that controls about whether or not the scoring system that he used to score these tests, whether that was valid or invalid. But the fact remains that whether he used a valid test scoring system or an invalid scoring system, he left the results out of his report. He ignored results from the tests he gave when they didn't fit his diagnosis. Results like possibility of defendant malingering, or malingering is likely. Those were results of tests that he gave to the defendant, that he came in and testified about what a great test giver he is, how experienced he is. And yet when the results didn't fit with the diagnosis that he was hired to give, he didn't include them in his report. Judge Taylor is going to tell you, as part of that insanity instruction, that even the most terrible crimes are committed under the influence of an impulse that overcomes the restraint that ordinarily prevents a person from committing a criminal act. What does that mean? It means that even the most terrible crimes are committed under an emotion, without time to stop and think, and just committed under the influence of that emotion, even though the person ordinarily wouldn't have committed the criminal act. Michael Barisone obviously had restraint on July 31st. He didn't shoot anybody. August 1st, he didn't shoot anybody. August 3rd, 5th, the other days he called the police, he didn't shoot anybody. But he shot 2 people, shot at another person on August 7th. And yet, Dr. Hassan gives a test to the defendant and ignores a result that says impulsiveness, ignores a result that says chooses not to keep or control his emotions in check. He gave the defendant tests that showed that the defendant could have acted impulsively, could have acted under the influence of those emotions, and he didn't put any of it into his report. Why? I would suggest it's because he wanted to deceive you. He was hired by the defendant to give a certain opinion. Was Dr. Schlesinger is a hired gun? How was Dr. Hassan any different? Now, Dr. Simmering is different. Dr. Simmering is obviously testified. You did hear it. He's testified on behalf of defense attorneys, on behalf of prosecutors. He testified or was retained by my office many years ago at some point. But an expert's opinion is no better than the facts on which it's based. His opinion is no stronger than the facts that he has. Imagine a person needs to go to a doctor. It's not in the criminal context, but has to go to a doctor and researches the doctor and tries to find a doctor who's very qualified, has great credentials. Everybody raves about this doctor and how great they are. And so the person goes to see that doctor. Goes in, sees the doctor, and the doctor says, nope, no, too much. Take too much time. I don't want to hear it. I don't need to hear it. Here's your diagnosis. That's basically what Dr. Simmering did in this case. How many times did you hear him say to me, counselor, I'm not going to read all the discovery. Counselor, there's too much discovery to look at. He looked at the things that Michael Barison gave him. He looked at the things that Michael Barison told him were important. And then he came up with a diagnosis just based on that limited amount of information. His report makes that clear, and I hope that it was clear to all of you. I was not pointing out all the inaccuracies or all the errors to embarrass the doctor. That was not my intention. The reason I pointed those out was to point out all the places where he made incorrect assumptions, all the places where his report was inaccurate. Do you remember we talked about he doesn't listen to statements? Dr. Simmering said, I'm not going to listen to all the statements. That would take me too much time. So what did he do? He relied on the police officers' reports where they summarized what they thought the statement said. And then we pointed out his summary of the police officer's summary was inaccurate. He was summarizing the summary differently than it was summarized. I know that's hard to follow, but the takeaway is that he was putting things into his summary that didn't come from the statement. He was putting things in his summary that came from things the defendant told him, things that weren't true. You heard the DCP&P caseworker. She testified that she was there not to investigate a sexual abuse claim. She was there to investigate a child abuse or a neglect claim. That's what she testified to. She wasn't even cross-examined. And yet then Dr. Simmering takes the defendant saying they were there to investigate sexual abuse, and he puts that into his report. And he relies on that, even though it's wrong. It got worse. It got worse just because he was talking about social media posts. Mr. Belinkis did a big deal about these social media posts. Do you remember when Lauren Kanarek was cross-examined about some of her social media posts? Mr. Belinkis pulled out a bunch of different social media posts and he said, didn't you post this? Look out, world, here I come. And she said, yeah, that's from a musical. That's from The Greatest Showman. It's song lyrics. And then we went through the day. She was posting that. She was listening to a Meatloaf song. And then she was posting about some other type of song after that. And yet these are the posts that are supposedly driving Michael Barisone to this delusion of fear. Mr. Belinkis cross-examines her on this post about the guns. This horrible, frightening, terrifying post where Lauren Kanarek says, yes, I do own guns. Do you remember what he left out? Do you remember on cross-examination when Lauren Kanarek read the rest of this post, where it said, they're both in North Carolina? That part was left out on direct cross-examination. We had to clean that up after Mr. Belinkis questioned her, because he left that part of the post out. And then this is the same post that's apparently given by the defendant to Dr. Simmering, where he says, look, Doc, She's posting about guns. I was frightened. I was in a kill or be killed situation. Then I asked the doctor, well, doctor, he gave you that post. He said he relied on that post. He was terrified of Lauren Kanarek because she posted that she had guns. Did you listen to the 911 calls? Yes. Did you listen to the 911 call on July 31st where the defendant is asked, have any guns or weapons been mentioned or threatened? His answer on the call, no. The doctor said he was aware of that. On August 1st, the defendant calls 911. Are any weapons mentioned or threatened? No. The doctor was aware of that call. On August 3rd, the defendant calls 911. Are any weapons mentioned or threatened? Not that I've heard a word of. The doctor was aware of that. And then on August 5th, the defendant calls 911. Were any weapons threatened or mentioned? His answer, not so far. The doctor said that he knew about all of those calls. The week leading up when this delusion has supposedly crippled the defendant into the fetal position, where he believes on August 7th the only thing he can do is take a gun and try to kill Lauren Kanarek because of this delusion. And yet when he's calling 911, he's not saying a word about any of these threatening posts about firearms. And then he tells the doctor, this is what drove my delusion of fear. But perhaps the most troubling thing that came up when Dr. Simring testified was when he was shown a series of what were called posts, social media posts. And he said, yes, these are posts that Michael Barisone gave me. He said he saw these posts, he said he relied on them, and I relied on them. Do you remember on cross-examination, I asked him if he was aware that one of those posts wasn't a post at all. It was actually a private message that came from Facebook that my office turned over to the defendant in discovery. And then the defendant is giving that private message that there is no evidence he could have ever seen before the shooting. He's giving that to the doctor and saying, look what she's posting, look what this says. And then the doctor bases his opinion on that. If you believe that the doctor relied on inaccurate or false or incomplete information, you can discount his entire opinion. And I would suggest that here, neither of the doctors that the defense called are credible. For different reasons, but that their diagnosis of delusional disorder should be rejected. Now, Mr. Belinkus talked about Dr. Schlesinger and said, Dr. Schlesinger's a hired gun. He says whatever we want him to say. He said he didn't even come in and testify why he disagrees about the delusional disorder. My recollection is that he testified to what a delusion is. A delusion is a fixed false belief that's not based in reality. And he said in his opinion, in his review of discovery, in all the time he spent with the defendant, there's no evidence that the defendant was disconnected from reality. Everything that he said was connected to reality. Dr. Simring testified a delusion is idiosyncratic. And I said, doctor, what does idiosyncratic mean? It means it's unique to this person. No one else thinks the same thing. And then Dr. Schlesinger said, well, didn't everybody have concerns and fears and find these posts that Lauren was making threatening in some way or another? You heard that testimony. That's not made up. And yet the defendant is the only one that had a delusion, or did everybody have the delusion? Doesn't make sense. The last thing that I'll say about Dr. Schlesinger is that he testified about that issue of malingered amnesia. And if you remember, he basically said malingered amnesia means that the person is faking. And both he and Dr. Simring testified there is no memory disorder that's selective for criminal behavior. What does that mean? It means there's no memory disorder, whether in the DSM or anywhere, that a person would forget just the time when they're committing a criminal act until they're finished committing a criminal act. There's no memory disorder for that. And yet that's exactly what you have in this case. The defendant has an excellent memory of everything that Lauren Kanarek did to him, of everything that he was feeling and experiencing in that week leading up to the shooting, even up to that morning when the caseworker shows up. And then he stops remembering the moment he puts his hand on a deadly weapon. He stops remembering the moment he loads that deadly weapon and goes to confront her. He stops remembering the part where he shoots her twice in the chest and tries to shoot Rob. And then he doesn't start remembering again until he's at the hospital. And the first thing that he says at the hospital, when he opens up his eyes and he's in the hospital bed and his arm is all bandaged up because it's been broken and he's all beat up, he doesn't say, "Where am I? What am I doing here? How did I get here?" He says, "They destroyed my life. I had a good life and they took it all away." That statement wasn't made in a vacuum. That statement was made after he supposedly doesn't remember shooting these two people. The DSM, famed or malingered amnesia, says people will often spontaneously confess when they're faking. Was that a spontaneous confession? He didn't have time to necessarily come up with a plan. Mr. Boinka said, "It'd be way better for me. It would be so much better for me if he made up that this was in self-defense." But he didn't do that because that's not what happened. Did the defendant know and appreciate the nature and quality of his acts? That's the other part of the insanity defense. So if you believe that the defendant has convinced you that he was delusional, that's not the end of the inquiry. You still have to decide whether that delusional disorder made it such that he didn't know the nature and quality of his acts, or that he didn't know what he was doing was wrong. And the judge is going to tell you, you do not have to rely just on the doctors for this. You can rely on your common sense. You can rely on the other evidence that you heard. What did the other evidence show? All the same things that established that the defendant wanted to kill show that he knew the nature and quality of his actions. Everything had fallen apart. The working relationship, the business relationship, the social relationship, the farm is getting shut down, police are there, town officials are coming, lawyers are sending fake eviction notices, everything has fallen apart. Then I ask, from a common sense perspective, what's the trigger? What makes it on August 7th, 2019, defendant hasn't seen Lauren or Rob at all that day? What makes the delusion at that point click? Turns off his memory and makes him say, "I have to go kill or be killed." This delusion of fear has now driven me to have to go and kill. It's the DCP&P caseworker showing up there. Not to say, Lauren and Rob called us and said something about you. The defendant isn't sitting in his office, doesn't look out the window and see a bird flying overhead and believe that the bird was sent to spy on him by Lauren and Rob and that he has to go kill them. He sees the caseworker there and he decides in that moment to act impulsively, to act emotionally, and to act purposely, and to go try and kill Lauren and Rob. So I would suggest the evidence shows that the defendant did not carry his burden with respect to the insanity defense. So to wrap up, the evidence in this case brings us back to where I started my opening 2 weeks ago. A sprawling, picturesque 50-acre equestrian farm in Long Valley, New Jersey. A place where Lauren Kanarek, who's an aspiring rider, had gone to train. And she didn't just pick this place for no reason. She picked it because of the defendant. She wanted to go there to learn and train and become a better rider. And if you remember the testimony about this picture, she said she did become a better rider. She said this picture was taken after she had just achieved, I think it was her bronze level or something of that nature. It was a big achievement for her. It was a big step along the way. Did these look like people who always hated each other? Were always scared of each other? They looked pretty genuinely happy in that picture, probably because she had just accomplished something, and the defendant had helped her like he had helped all those other people along the way. Now, on the afternoon of August 7th, 2019, at that farm, a DCP&P caseworker pulls onto the driveway. She pulls up the driveway, she goes past the farmhouse on the left, she goes up over the rise and pulls down into the parking lot. She parks the car in the parking lot in front of that stable and the big clubhouse, all the training arenas nearby, and she gets out and she sees a man. That man turns out to be the defendant, Michael Barison. A great horseman, a very well-respected, highly regarded trainer. A coach and trainer who knows that respect and trust are the keys to success. Who doesn't have any respect or trust anymore for his student, feels like she doesn't have any respect or trust for him anymore. He's frustrated. Furious, you could say. Not frenzied, not frantic, not freaking out, but furious. Maybe seething is a better word. Frustrated, perhaps desperate, emotional. Emotions are not delusions. And he's feeling very emotional at that point in time. When the DCP&P caseworker identifies herself as being from DCP&P, he's at his breaking point. He's not delusional. He's not freaking out. He's reached his breaking point because 2 days before, his mentor, George Morris, another great horseman, had just been given a lifetime ban from equestrian competition. And in that moment, in the parking lot at his farm, he envisions the same fate for himself. He imagines that Lauren Kanarek must have done this. She must have called. She must have reported him for sexual abuse. It's not what happened. That's what he imagines in the light of everything that's going on. And for doing that, she has to die. The caseworker goes inside, and she meets with Mary Haskins, the mother of the children. And the defendant interrupts once, interrupts twice. On the third time, he interrupts and says, "I need the office now. You have to go somewhere else." And on her way out the office, he stops her and he gives her a goodbye kiss. He says goodbye because he knows and appreciates exactly what he's about to do. He goes into the safe, he opens up the safe, and he takes out Ruth Cox's gun. And he loads the bullets in the gun, and he makes sure to take an extra magazine of bullets in his pocket with him. He purposely picks that deadly weapon at that moment because he knows and appreciates exactly what he's about to do. He goes outside, he gets into his truck, and he starts to drive. Starts to go confront Lauren and Rob. And in him going to confront his enemy, he knows and appreciates exactly what he's about to do. He parks the truck, he gets out. He intentionally stands behind a bush where no one can see his waistband, no one can see his pocket, no one can see his hands. And he says to Rob Goodwin, "How can we end this without a war?" He knows that he's armed with a deadly weapon. He knows there will be no war because he's about to commit murder. But he waits. He waits until his enemy, Lauren Kanarek, has stepped down off that step, until she's no closer than Mr. Belinkis is to me right now. And then he hits his breaking point and reaches in and pulls out the gun and shoots her twice. And as Rob Goodwin tries to flee from him, he tries to shoot at Rob, but the gun is out of bullets. None of what I just said was driven by any sort of an emotion, delusion of fear. everything I just said was driven by the defendant's emotional impulses. So in closing, I would ask that you not return a verdict based on any sympathy, disgust, or emotion, but that you return a verdict that's based on reason, based on facts, and based on the law. And I would suggest if you do that, you will return a just verdict of guilty. Thank you.
Thank you, Mr. Shellhorn. Ladies and gentlemen, it's about 10 after 12. My charge will take a decent amount of time, so I'm going to give you an early lunch break today. You've been sitting all morning. Come back after your lunch break at about 1:15, and I'll give you my charge then, and then we'll select the alternative jurors, and then you'll begin your deliberations. It's important now, you've heard all the evidence, you've heard the summation, but you have not heard my charge on the law, so again, I emphasize to you, please do not discuss the case with yourselves at all. Very shortly, you will be allowed to discuss the case fully and completely in the jury room by yourself with all the evidence. Please don't start any deliberations before that. Enjoy your lunch. We'll see you at 1:15.